Good afternoon. Welcome to the next episode of Optimum Live. Episode 7 we're at now, and we're going deep today. Poor Iain Mason, our person in the hot seat today, head of legal here at Optimum. I think he's been here shaking his head for about the last 10 minutes because this is deep, but we're going to try and help you as much as we possibly can. I think that sums it up, Iain, doesn't it?
Yeah. Keep it simple.
Keep it simple, yeah.
Keep it simple. I'm very happy with that. Yeah.
Well, we both agreed is that there needs to always be a case-by-case basis with the subjects we're going to touch on today, but it's really important to get at least a grasp on the basics and to know that there's a conversation to be had.
Yeah, absolutely. Yeah.
I mean, I was there, even myself, when we were going, right, this is the topic. I looked at it and went, oh my gosh, I didn't know that I needed to bear that in mind. Yeah. The subject that we're going for is owning a property with another person. Now, this isn't just husband, wife, boyfriend, girlfriend, or anything like that. It could, and it's not even just domestic, it could be commercial property as well. Mm-hmm. If you are planning to own that with somebody else, that's why it's deliberately vague, because whether it's friends, family, business partners, I'd imagine there's a few others we could throw in there as examples.
Yeah, I mean, yeah, you could be, because I mean, if you start getting into the commercial context, you're then looking at, right, do we even own it in our own names, or do we put it into a company?
Yes.
And then we've got a question of the ownership of the company, which is a separate topic of conversation, but it's the, I guess it's the same principle. In that, yeah, if you own something outright by yourself, well, it's pretty much yours to do with what you want.
That's easy.
Yeah,
exactly.
Get somebody else involved. Yeah, it starts getting a bit more complicated. And I guess, look, you don't know what you don't know until somebody like me or somebody down the pub perhaps tells you, oh, have you thought about that? And then it's, oh yeah, I wish I'd known that however many months ago, years ago, or whatever, or other. Yeah, that saved me.
Hindsight's a wonderful thing.
It is indeed.
It's made for this bit.
Yes.
I mean, first of all, let's just make sure we position why we're even discussing this. By the way, everybody that's watching this, please feel free, put comments or questions on and we can put them up on the screen. So if anything comes up you want to ask, if it's after the live that you're watching this, please still feel free, or drop Iain a line. In fact, I've got Iain's email address. Where did I put it? There it is, imason@optps.co.uk. So if you're watching it after the live, drop him a line and he'll be able to answer them. So before we get into joint tenants in common, we needed to start, by the sounds of it, on this beneficial interests and the legal ownership of it. I mean, beneficial interests, what does that mean?
I guess in simple terms, if we're talking about property, it's basically the monetary or equivalent, the value in it. I think before we kicked off, I was talking to you about I help people move houses, or I help people buy and sell property. Most people talk about, oh, I'm moving house. I can remember a conversation with my children when they were smaller, and they thought, right, you actually help people physically move their house. Yeah. I said, well, no, it doesn't quite work like that, guys. Yes, you've got the removers to remove the contents. Yes, that's moving house, but physically moving the building, it's not like it is in the States where you see them doing that. We don't tend to do that. So they're moving their house. Yes, you can see your bricks and your mortar and you can see your roof, but the reality is that's the physical object. That's what you own. But the beneficial interest, the bit in the background, it's the cash, it's the value, it's that's what we're talking about in the simplest terms. That's the beneficial interest. When I've sold a house, do I get a big pile of cash at the end of it? Yeah, realistically you would do, or you get a bank account goes.
Not as in, do I get half of the brickwork and you get the other half of the brickwork? It's like, no, how much of the cash do I get out of it?
Yeah,
That makes sense.
Yeah, absolutely.
And the reason why that's important is that that's the catalyst for every part of this discussion we're about to go on now.
Yes, pretty much.
Yeah.
Yes.
It's the beneficial interests of that investment, if you will.
Yeah.
It just happens to be bricks and mortar.
Absolutely. I mean, you can see the physical, tangible asset, the house. Yeah. And if the roof needs repairing, if you're the owner outright, you own it by yourself, that's on you.
Yeah.
You can get buildings insurance for it. Now, when we say there's two of you, yeah, and you own the house, right, buildings insurance, most people would say it's a good idea to have. Yeah. Okay. But there's a cost associated with buildings insurance. Yeah. So who's going to pay for that? Is that split 50-50? Or is one responsible for it? What do you do with, how does that all work? And I guess this is the...
I'm kind of almost envisaging is that should be at least fairly straightforward if there is two of you. I mean, if I just go domestic as a simple example, two of you living in it, and it's a 50-50 split, then it's a 50-50 split on the costs.
Yeah.
But if it's an example where somebody's not living in it or working in it, or it wasn't a 50-50 split from the get-go, I'm assuming that's where it can start getting a bit murky.
Yeah, absolutely. I mean, because look, I could own a property with somebody else and it's held in trust for my kids. I might do that because they're under the age of 18. They can't own property in their own name. I'm legally responsible for it, looking after them on the terms of the trust.
Yep.
So the onus is on me then as the legal owner and the trustee to see them right, to pay all of the outgoings and everything else that goes with that. Now, if it turns out that I've been asked to be a trustee with somebody else for, I don't know, grandchildren, or I'm with my sister or my brother, something like that.
Yeah.
And it's all the properties being held in, not just for my kids, but my nieces and nephews, say.
Yeah.
Yeah. What's the deal that I've then got rolling with my sister or my brother for that? If he's a bit not as financially well off as I am, or has 1 month where he can't, he's a bit short. He's between jobs for whatever reason. The obligation still rests, the legal ownership. Yeah. You're the one whose name's on the paperwork. The council tax don't get paid. Yeah.
Yeah. I mean, I'm thinking out loud, and again, apologies
if
I'm going to bring up silly things
here.
Yeah, and it may be silly comments or questions I come up with here, but does that mean that you could have it where you are the legal entity because the other parties, they just couldn't get to the table in the way that was planned at the outset? However, the longer term goal is for this split. Therefore, the theory is we're all splitting the costs equally. Can you do that if that's separate from that you are the owner and you're intending to split the costs afterwards?
You can do.
But it'd have to be in writing, presumably.
Well, that's the idea.
Yeah.
And that's kind of where we almost get to. It's only when you get to the back end and it all seems to have fallen apart that you're then trying to work out what was the deal in the first place.
Yeah.
Because there are different ways of doing it. We see it quite a bit with, I suppose the biggest issue, this is almost where this area of law interfaces and interacts and intersects with other areas. A bit like the whole idea, people seem to think, oh, he's my common law husband, they're my common law wife. Well, it doesn't really, the concept doesn't really exist. I know it does in Norway, but it doesn't over here.
Oh, really?
So if you're unmarried and you buy a property together, yeah, and you split up, well, it's not the same as if you were married in terms of the rights that you'd have if you were married. The law doesn't really operate. So we often see that's almost the tricky one. If you're cohabiting and you're buying with a boyfriend and girlfriend, or partners, a couple of chaps who aren't married, aren't in a civil partnership, buying a property together, that's where it becomes the law doesn't necessarily help you. And it's, again, as I say, if you don't know something, it's only when it does become an issue that you suddenly think,
too late.
And a lot of it is probably just a conversation at the start. It might be that somebody's got an inheritance and they've got the lump sum to put in by way of the deposit or take a chunk of the purchase price. Yeah. But they haven't got a particularly high paying job. Yeah. Mm-hmm. And the other person involved has got plenty of gets the income, so it can deal with the monthly outgoings, but hasn't got the lump sum in the first place.
Right.
And you can have that conversation and work out, right, okay, well, if I've come in with, I've dropped in, say, 20% or 25% of the value of the property when we bought it, on the back end, on the exit, yeah, we have an agreement that, right, 25% of whatever the value is will always come to me.
Yeah.
And then you can work out what the gig is with the other 75%. And that almost is where, if the balloon does go up and there is a dispute, that's the sort of thing that needs to be put in front of either try and have that conversation between yourselves to work out who gets what.
Yep.
Failing that, it's going to probably be in front of a judge.
And then it starts getting pricey.
Well, yeah, if you've got to that stage,
Yeah,
because you'll have probably been through the lawyers, and if the lawyers haven't been able to reach an agreement and a negotiation, you're then looking at the courts to make the decision for you. All of this is brought forward and would need to be put in front of a judge to kind of make a decision as to whether or not, right, okay, that particular moment in time, you brought that bit forward. You were short for 6 months and couldn't make your mortgage contributions. Yeah. And this is where I'm sort of right on the edge of really doing, as you said, the deep dive into
it is
sort of the law of equity.
And this is where I've got to drag you back. I know we have to keep doing that. That was,
and you're quite right to do so, because I'll ask me in particular a question. I can go off.
And which is brilliant. Yeah. And if anything, the key point I want to make on that is that the conversations are there to be had. You know, it's like, come and talk those specifics with you, even if you find out there's nothing unique about it. It's better to be having those conversations and be sure.
Yes, I think that's basically it. I mean, it's
But I'm getting the impression, Ian, that it's worth having the conversation before you go down the path. And equally, if you think you've done the right thing, hindsight's a beautiful thing, and something changes. You know, it could be a relationship breaking down, it could be a financial situation changing, as you were saying, for one, not the other, or whatever it might be. Again, there's another conversation to go, right, what's possible, what needs to happen, etc. And that's where you get specific.
I think, absolutely. I mean, as I say, it's knowing the questions to ask as to when the timing to be asking them. Yeah, we have different trigger points. And that's not to say that if you find yourself in a situation that, oh, crikey, we need to have a think about this. But sometimes that's more of a, as you say, a separation, moment of crisis. But it might be just, well, actually, haven't thought about this. I know we bought that property together a couple of years ago. We probably need to have a think about it. You can always make that decision.
Yeah, there are options.
Yeah, you can then formalise it, thinking about, well, actually, that's a good point.
Which does throw up another element for me. I kind of went all dramatic on you then, in the fact that I was like going, it all goes wrong and you have to change. It's like, no, situations can naturally change, and it might not even be the final rip a band-aid off. It could be, actually, we need to revisit this now because situations are tweaking.
I think there are life changes. I mean, that's the other thing is second, you might get a bigger job, you might come into an inheritance, something might happen in the wider world. There are various triggers, and I suppose it's a question of just being alert to it.
Yeah.
I mean, the reality is, what could you say? An investment strategy would involve, right, I'm going to put some in a bank account, I'm going to put some on stocks and shares. You could have a very high risk but lucrative investment strategy which involves the 330 at Newmarket.
Don't start giving me tips
that. No, I'm not saying a tip. I'm just saying that is a potential strategy. It might not be a very good one, but at least you've still got one.
Agreed. I know what you mean. I'm going to now get into a couple of specifics of two titles that really sort of break this down.
Yes.
Joint tenants and tenants in common.
Joint tenants is the easy one.
Okay.
Basically, joint tenants, if you have two people, the legal is you've got the legal, the beneficial we've talked about. Legal, you've always got two people, there'll always be two names at the land registry. All right. You can't do anything about that. When it comes to the beneficial interest, if that's held as joint tenants, it's again, there is one share, two people own one share, but that one share can't be split.
Yep.
So in simple terms, if either of the joint owners dies, passes away, it automatically goes to whoever the survivor is. It's as simple as that. Comes as a surprise actually to a lot of people with bank accounts. A lot of bank accounts are joint tenants in sort of law and equity. Two names on the account, it passes automatically to the other one. So with houses, and I suppose in some respects you could say that's almost the traditional model. If you're a husband and wife, all being well, you'd hold it as joint tenants. Why would you not? If one of you
Agreed.
passes, you want everything to pass to your spouse. And so with joint tenants, law, equity, law and the beneficial interest just goes over automatically.
Okay. Yeah.
Yeah. So that's the nice simple one. So when you get to somebody passes away, and okay, well, we won't get into IHD and probate and the rest of it, but it automatically goes at law. Yeah. So there is this concept of, well, we were talking about, oh yeah, there's the cash equivalent value. Well, all of that just goes to whoever's name's left on the paperwork. And I say that there's two, you could have more than, you can have, say, 3 people. Say I had 3 kids and I left a house to them. Yeah, all of their 3 names, they were all on the deeds. Whoever ends up outliving the others gets the pot. Yeah.
Yes. And, you know, we said it's not just commercial, it's not just domestic property, it's commercial. That very easily could be more than 2 people.
It could be. I think the context in a commercial property, you'd probably, well, this is where you get into the territory of what's most financially advantageous. And you'd probably almost be having a chat with your accountants about that one.
Which is why we have head of legal here as part of Optimum, because you guys are so intertwined. I mean, I've made a note there is that this starts crossing over into wills and probate, which we're deliberately not going to go down that rabbit warren too much. But equally, I mean, even in terms of pensions is another one as well. You know, especially when we talk about commercial, I know of plenty of people where there's like multiple peoples in the peoples. There we go. People.
I know what you mean.
People in the business, and they make that their pension, and they're sort of the rent that's coming in from the residents.
There's sort of plenty. I think if you had a pension in your pension property in your sole name, the rules vary depending on whether it's a SIP or a SAS or whatever. But yes, there is that. I mean, the longer term, you've got different vehicles essentially for how you hold property.
Yeah.
So really, in the sort of the commercial arena, I think we then get into the territory of you looking at an incorporated structure. So whether it's I don't know, SPV, company limited by shares, simply because of the tax consequences of, do I want it in my own name, when it's actually a business property. Yeah.
Because I'm conscious, I can even tell from the look on your face as I said it, is I'm taking you down a whole other area there that I'm going to be careful not to do. But is that where, and I'm intrigued now as a sort of a layman out of this, is that where suddenly, like, you as head of legal and one of the other team within Optimum from the finance side, whatever side that happened to be, would end up in a meeting with a client together because you've both got to have an input into this?
Potentially, yeah, because sometimes somebody will come to you with a structure saying, oh, I want to do this.
Yeah.
And you'll be thinking, well, have you spoken to your accountant or your financial advisor about this? And they go, why would I need to? And I think, well, legally, it's one thing. But I think increasingly from our perspective, the expectation as professional advisors is you can't be quite so siloed as perhaps it once was.
Yes.
Simply because of almost the blowback from your regulators and whether you're doing your job properly as a professional. Yes, I am a solicitor. Yes, I am a lawyer and I've got legal knowledge, but on the back of the experience that I've got, there are touch points where, am I doing my job properly by just looking at it from, well, I guess from your filming background, you put one sort of lens on the screen.
Yes.
Yeah, you're only going to get one sort of image, but it's not going to be the whole picture, is it?
Which is one of the things, and again, I'm allowed to say this because if you didn't, it's biased. That's what I love about Optimum, where the fact that you've got this mixture in house, and you've explained it to me perfectly. There is that, if you were working for a law firm purely, then you would only be thinking from the black and white. That's the law. Whereas you're kind of going, no, we're thinking of this from a financial, which is what we've been sort of starting on. I hope you're all still with us because I know this is deep, guys. I get you. And again, as I say, if you're watching, ask questions, please do, if there's anything that you want to ask. But so joint tenants and tenants in common. Joint tenants, as you say, that's the easy one. You know, they do say the advice is kiss a frog. I do the hardest one first, but you started with the easy one.
Yeah, I did.
Tenants in common. What's that?
Right. Well, the one share that I was talking about. Yeah. If you go tenants in common, you can split that however you want.
Okay.
So if there were two of you, you'd probably go, right, 50-50. Yeah. Particularly if you've gone in, I suppose, you come in together, we buy a property, we put the same amount in from the start, we've got a mortgage on it, we're both contributing equally to the mortgage. So everything that goes in, there's two of us on the title,
Yeah.
and what goes in is what we get back out, 50-50. Yeah. Now the tenancy in common is where, right, it gets a bit more interesting. Yeah? Because you could have two people who've bought the property, and there's actually three people in the background, the two who bought it, and then maybe one of them got a bit of cash from somebody else.
Yes.
Yeah. And the somebody else in the background.
So that could be a parent or of one of them, for example. Yeah.
Potentially could be saying, right, what do I get out of this?
Yes.
So what's my interest on it? And it might be that they're not happy. It was a gift, so they're not expecting anything back. It might be that it's actually, right, I'll sub you 15, 20, whatever proportion of it, but I'm expecting something back. Doesn't have to be right here, right now, but when you do end up selling it, I'd like to see my little stake back. That third party doesn't need to be on the legal title, but it's certainly there in the background because they've thrown in to help make the contribution. It might be that you could end up, and I suppose this is where you get into the disputes, say that we're talking about the two, one of them struggled, took a bit of money from somebody else in the background, wasn't entirely clear how that other money from the third person came in. Do they suddenly turn around and say, actually, I lent you some cash there, you've used it for those purposes, right? I'm expecting you use that to do that to that property. I want my
bit of cake back.
I want my cake back.
Wow. Yeah.
And
I mean,
that's, it's,
and you can see why it would happen. I mean, I'm sure when my wife and I were sorting out our wills, they were even sort of trying to advise us to have this tenancy in common.
Well, that's, I mean, you've touched on it as well, because a lot of the, certainly, and I've seen this, well, without going into too much detail, with the changes with the inheritance rules, there was, for a time, the advice was to split the tenancy, sever your tenancy, so it's held tenants in common. One bit goes into somebody's estate, the other bit goes into somebody else's estate, because of the changes in the threshold, rising property values. But again, there are certain changes that have been made with the legislation about spouses being able to leave property to spouses, which then don't get brought into the equation for calculating the estate for inheritance tax. So and that, I suppose, is another point you were touching on, like, when are the points to look at my arrangements? Well, it might be, they sort of say, look, every 5 years or a life change, it's worth looking at your will. But the other side of things is that the legislation changes, that there are, and because of those changes, that I think the current iteration with the IHT relief, I mean, if you're 20, you're probably not going to be worried about
rightly or wrongly.
30, maybe you might have children by that stage. 40, 50, as you go through, I guess your life, your flight path or your trajectory, certain things on the way in, you're probably not going to be worried about. I'm never going to be worrying about a pension. I can't afford my avocado on taste. What am I worried about? What am I worried about? What's going to happen when I'm 50?
You're reading my thoughts there, Ian. That's freaky.
And I think so. Some of those, in terms of you mentioning your wills with your wife about that, will have been driven by what the arrangements were with what was most advantageous.
I think they were sort of throwing considerations at me, and I was like, wow, okay, that was the first exposure I had to this difference between the two. I don't know whether we can, because it makes sense. I get it. Is that literally the joint tenants is that the value is 100%. One person. Let's get the most obvious. One person passes. That goes 100% to the other person. But the tenants in common is that you then have an agreed percentage per person or entity, I guess we should probably call it, because that could be an organization, couldn't it?
Well, it could be anyone. I mean, fundamentally, with the tenancy in common, so if you've got the beneficial interest and you've split that, there'll be an agreement as to what's the size of the share that I have in what the cash or what the value is. That is owned absolutely by the person. That share, when the property is sold, so whether it's 50-50, 70-30, 60-40, that is that person's to own, to do with as they see fit.
Sure.
It forms part of their estate, so they can leave it to whoever. So you and I bought a place together. It's an investment, not together.
That's fine. There's no need to defend it quite so much.
No. It wasn't meant like that. It's just for the sake of it. We buy commercial property, or no, we don't. We just buy a resi property. It's a buy to let.
Yeah.
No, they're probably not anyway.
Not go down that route.
No. So we bought a place as an investment, and we'll take out what we put in. So we go in 50-50, all your bills are split 50-50, what's left over. I would basically say that's my money. That's because that's the nature of the beast. That's the deal. That's how we were working with it. Now I could choose to leave my 50% in it to you, but more realistically, I might be leaving it to my children. It's mine.
Yes.
It's mine to do with what I.
And again, I might be going off on a tricky tangent here, which you've now seen I have a habit of doing. But if you turn around and then said, right, I want to sell, and I said, but I don't want to. Well, I mean, if you're joint tenants, that's just an argument that's got to find a resolution. But how does it work when you are these tenants in common? You've got a 50% right to have your way.
Well, that's absent anything.
Now I know I've got trouble.
Because this is you're then getting into territory from. I think you're then looking at the Trustees Act, or more importantly, probably what is called in the trade Talata, the Trust of Lands and Appointment of Trustees Act, because where you've got property involved, you've got certain implied trusts that are set down by statute.
Okay.
Yeah. So this is because obviously the whole concept of legal law and equity's been running for an awfully long time. It's a separate history lesson in law, almost, as to where that came into existence.
Right.
So there is stuff in the back. There's a degree of legislation in the background that would help if a property is owned in trust. There's a number of implied legislation and implied rules that come into it. I mean, fundamentally, if you've got where you almost end up almost in front of a judge trying to argue your case, you can bring a claim under a trust of land. There is a power on the trustees they've got the power to sell, but as you say, normally if there's two, you both need to be in agreement. If you can't reach that agreement, right, one of the parties can try and have a go under the legislation.
Or presumably, is that where it would then be going, well, fine, then you've got, I'm the one that's saying I want to stay put, you want out, then I would have to buy your 50%.
Well, potentially,
Or get someone else to buy that.
Or get somebody else
50%.
Or, and this is where you've got, where difficulties arise over the decision to sell a property. Any person who is a trustee of land or has an interest in the property subject to a trust can apply to the court for an order. The court may make any order it thinks fit to resolve the dispute, including an order for sale. So,
wow.
But you'll know how I have couched that with the cans and the mays.
Yes.
It's
not a guarantee.
It's not a guarantee on it. And this is almost where you're, do you try and do the hard thinking at the start? And you can probably have most of a route map as to, right, okay, if I want to sell, what do we do? Right, I offer you first dibs on it, and if you can raise the money, you buy it.
So that can be in writing as well.
It can be, or do we just take our chances and say it just gets sold on the open market?
Right.
And that's the other thing, certainly on a commercial property, if we bring it back to where we started with this example, that's kind of what you'd probably think about. Because if you're buying this as an investment, most people with an investment will want to be seeing some sort of return.
Of course.
Yeah. So you're looking at,
it's not your forever home. It's an investment.
No, it's a different concept. And sometimes this is where I guess with property in England or in the UK, we're an island. There's a finite amount of space. Increasing demand for various reasons for housing.
Absolutely.
I think it's pretty clear there's probably not enough of it. But from one perspective, you look at, right, I've got you've ever played Monopoly.
Yeah.
First rule, if you get it, you hold on to it for as long as you
Absolutely.
possibly can. Yeah. And I think that's over the long term. I think, yes, we might get blips, but property as an asset class.
Yeah. Well, it always reminds me many years ago is a stand-up turned around and said, everybody's freaking out that, property values are dropping, and they're going, what am I going to do with my property values dropping? And he said, I'm going to live in it.
I think, and this is it. From a residential perspective, why do you have a house? Because you want somewhere to live.
Absolutely.
Yeah. The fact that the value's going up in the background should be seen as a bit of a bonus. You're focused.
Exactly.
I don't know. My worldview is
you only lose out if you're trying to sell it.
Well, basically, but if you want a roof over your head and everything else is all right, does it really matter?
Keep going. Yeah, exactly.
But that sounds a bit. I
know I'm
a bit idealistic,
but especially when we get to remortgages and things like that. I get
absolutely.
That,
but if it was like, take that example, we bought a rental. Right, I've got coming to a bit of cash. I think I can make a turn on this. What am I going to be really looking at in terms of? Right, it's a bit of a wreck. We've done it up. Right, I know what my investment's going to be. What sort of return am I going to get from it? Is it going to be sold after 5, or should we hold on for it at 10? Don't know. It might be that we've just got an agreement that if we are both in agreement and I want to buy you out, well, basically we'll just say it gets sold at this particular. If the market reaches the certain value that we're hoping for it, that's when we sell it.
That's when we go. Yeah.
And I think this is I suppose it's the tricky thing. Is it the tricky thing? That conversation. What's in your mind at any moment in time? Yeah. What do we want out of this? And we can do the thinking. And I think this is certainly with I guess on the commercial one, it's probably almost a bit easier because it is essentially, so it's all about the money. The emotional side of things might not come into it.
No.
Yeah.
It might be the practical in the fact that we've now built this premises up to work for our business perfectly, blah, blah, blah. But I get that. All right. A difficult question. Which is best? Can you even answer that question? Joint tenants or tenants in common?
I think I'll sound properly highfalutin here. I don't think best or qualitative is really the best way of looking at it. It's very much a question of circumstance. And even then, what I might consider as best on a Monday, come Friday, I might change my mind. Yeah. Because sweetness and light with the missus on Monday. We've had a massive bust up and come Friday. Yeah. So while it's joint tenants on Monday, and I suppose that's the other thing, you can sever a joint tenancy whenever you want to. Yeah. Not as tricky. Well, sorry, not as straightforward with the tenancy in common.
Got you.
So essentially, there are some moments where you're almost looking at where a joint tenancy is automatically severed, which is where we get into the law. But typically, where couples separate or husband and wife separate, that tends to be a trigger for one or other of the parties to say, right, the joint interest that we had is now severed, and it's going to be what's mine is mine, and what's yours is yours, as opposed to what's mine is mine, and what's yours is mine.
That agreement goes into a different contract altogether, presumably.
Yeah.
I mean, I do have a question here. Who does this consideration apply to? I.e., not just couples is the most obvious, but I think we've touched on business partners, be that investment or a commercial property.
I think it can be. I mean, I think as I said, with a lot of commercial property, it tends to be, if you're at the stage where you're buying commercial property, you're probably already going to have a business or some vehicle for it. And the reality would probably be that you're looking at buying it via the vehicle.
Which is a comment we were chatting before we went on air, wasn't it? About, who is actually, well, isn't there a difference? And again, I'm going to freak you out by asking this because it takes us another direction, is that there could be the legal on paperwork owner could be different to the, you were saying something along those lines.
Well, I mean, I think that's it's almost like companies don't actually exist per se.
No.
They are legal persons in the eyes of the law, but they don't exist like you or me.
No.
There's not.
Well, because it actually exists of the directors.
Exactly. I'm looking at Chris Dawes. Yeah, I don't know if you've got Chris Dawes Limited. Well, who is that? Where is that? There is, but there isn't.
Yeah.
So it's almost the idea of, yes, there is a Chris Dawes Limited, that is the legal person which can own things, but there's somebody behind it which is where the individuals are.
Yeah.
Which is the shareholders, that side of thing.
Yeah.
So if you're with the commercial side of things, yes, depends, driven, I suppose, what's best, as you say, depends, right, best from what? Legally might be one thing, but normally we are the legal, as I see it, we are just one part of the wider jigsaw that's out there in the world. Yeah. The stuff that I own and I'm responsible for, legally, that's on me. Yeah.
Isn't this the bit that you were telling me again before we went on there, like the cup as an example?
Well, that is the analogy for beneficial interests. I mean, I've been qualified, I don't know how many years, and I still sort of struggle at times to try and explain the difference between the legal ownership and the beneficial interest. And I've variously heard it described as a banana, in that the legal owner, the trustee, owns the skin, whereas the beneficiary's got a nice bit in the middle.
Yeah.
I've heard it described as a cup, which is where, the physical cup, but it's the contents, the bit, the water, the beer, the vodka, whatever in there, and a pond. So that the water, yes, there is a pond, there's a concept, but what's in the pond, trustees are responsible for it, but they don't actually own it. Those fish, belong to the beneficiary. Yeah, so they've got to look after the ponds. Yes. Keep it clean, keep it swept, make sure the fish don't die, but the fish ain't theirs. So
no,
well, they might be. It depends what the terms of the trust.
Again, yes, Again, this may be a sort of overarching question that we've been kind of touching on already, but what are the kind of considerations or thought processes maybe that we would need to go through?
I think, I mean, going back to which is best. I mean, I think if you, I touched on the example that if you were, say, well, I don't know, 2025, and you're buying a property with a mate, or you're buying it with your first girlfriend, boyfriend, you're not made the commitment to get married.
Yeah.
I think in that sort of situation, you're probably looking at tenants in common.
Got you.
Yeah. Partly because you're thinking, right, I put my cash in, independent. I mean, marriage as a concept's not for everybody.
Mm-hmm.
But I think, unfortunately, with, I guess, history and society and where that's come from, I think, in all fairness, perhaps the legal system is lagging behind. Yes, we do have civil partnerships, which is one way of recognising a connection, but the whole idea of common law doesn't really exist in England and Wales.
Which, again, a whole other topic altogether, is that this is why it was so important and fought for that gay marriage was possible, because otherwise they're being unfairly limited.
I think, this is where I sort of say, law is almost, the legal system is, I guess, almost a product of society. And rightly or wrongly, we are where we are. I mean, there's all sorts.
There's still some way to go, probably.
Quite possibly with that. So really, if you were a couple who weren't married, it's certainly a consideration. It might be that you've got enough feeling for one another that you think, no, I'm not bothered if we'll just own it as joint tenants. It might be that you're slightly thinking, well, maybe life is going to change. And it might be that there's a factor, again, the example is parent of one or other of the couple of that, right, we'll help you get off your feet, help you get on your feet, help buy a property, here's some cash. Leaving aside what the lenders and the mortgage companies are, whoever's putting that money in, could be aunt, uncle, granny, grandpa, something like that. They'll be wanting to sort of say, well, maybe if I'm giving this to you, I want to make sure that you see this right if things don't work out for you. It's almost like an insurance mechanism.
Absolutely. Yeah. And that was where we were sort of saying, and again, I know we're trying to say that there's plenty of other examples, but let's just say romantic relationships is the most obvious one, but suddenly a parent of one of them helps them out, and then that breaks down. That parent's going, okay, but now, this person is no longer relevant to us.
I mean, it's the interface, I guess, between what I call the IQ, like the legal stuff, explaining the joint tenants and the tenancy in common, the IQ side of things, to the EQ, which is, right, what's the drive of this? Where there's two of you and you're together, there's just the two of you. Introduce a third party, that's another variable, because you've suddenly gone from that way to that way. You've now got 1, 2, 3. You've got somebody else involved in the mix, which is going to be, again, on an IQ perspective, you can work it out. But if the driver from this is, I'll give the money to them, but I want to make sure that you're all right. Right. A to B might be quite happy with that, but B's then got to go to C to say,
But presumably, and again, forgive me if I'm wrong,
No.
that's only an issue if, and let's just go with my simple example, and I'm conscious of time, but we, go here anyway, is that we were talking about the 3, but let's say, for example, in actual fact, both sides of this couple are putting in 50% of the collateral each, but it just so happens that this one over here has been given some of the funds by the parents, then that suddenly becomes irrelevant that there's a third person involved, presumably.
Provided, of course, that what you've said there was in fact a gift, because you'd be amazed at the number of people who think, I've given you something, but I will expect it back if the following happens.
But that presumably is just from
if that's
parents to siblings.
if that was a true gift, an absolute gift, there's no expectation. If I give you something, the whole point of it being a gift is that it goes to you.
But even if it's not a gift, and let's say this breaks down and they sell it, let's just go round figures, 100 grand, so there's 50 grand each, and actually I gave you 4/5 of the money to put back, so 40 grand of that goes to me, and you, daughter, son, keep 10 grand. That's a personal.
Again, driven by the circumstances, but I think if you were in that sort of argument, you wouldn't want to be the other party saying that all of a sudden that 40 that went in, because you could float the shares, couldn't you? Because you could limit it, and this is where it gets.
So we really need to get this in writing from the get-go,
because if you put 10 grand in, it might be that, okay, I'm happy to see 10 grand back. A lot of people say, right, 10 grand in a year's time, one thing. 10 grand in 10 years ain't going to be worth the 10 grand it was when it was paid because of inflation.
No, absolutely. Yeah.
So you can, with declarations of trust and how you structure these sorts of things, you can say, it's like, I just want the lump sum. I'll take back what I put in with an uplift allowing for inflation.
Yeah.
But if the 10% at the start was worth, say, I'll put 10%, 10 grand was 10% of the value, you turn around and say, right, okay,
I want 10% of
I want 10% back.
Yeah.
And that's how, I guess, as an example of what you put into a declaration of trust, as to what the arrangements, who's brought what to the party, and how we're going to deal with it.
And this then throws me on, and we're getting close to the end of this one, but presumably things can change, not from the dramatic that I've just used an example of there, but that actually that couple further down the line go, do you know what? I want to remove that third person from this. So you can work out how that third person, and the third person is totally happy, the family going, hey, yeah, this was just to help you get started. That's fine. Give us our money back or our percentage back. Could that be a change that could be sorted? That the two people left?
I think it's always open. You can always have a conversation. A bit like Parliament. The rule that Parliament can't bind a successor. You can make a decision. As I said, make a decision on a Monday. It was my intention. I do that. Come Friday, I can change my mind. I would need to do something about it.
And that's a key thing, is that we're talking legal, obviously, because that's your role and it's the basis of this discussion. However, there could still be a bit personal that we kind of go, hey, do you know what? Are you happy with that? And you go, yeah, I'm happy with that. And you go, done. Yeah. That can still be done on a personal decision.
You can do. I mean, if you
presumably that still needs to be in writing so that it can't be reneged on later.
This is the question as ever. It's always about the evidence. What was that?
Yeah, exactly. They go, no, I never said I was okay with that.
Was it a verbal contract's not worth the paper it's written? It's always this question of certainty. What was meant? I mean, yes, you and I can have a conversation, but it's all of the stuff that we see in the press. You watch the police procedurals or whatever, and there's an accident that happens, and what one witness swears that the car came from that direction, and the witness on the other side of the road said it came from the other direction.
Absolutely.
It all comes back down to well, I don't know, what is truth? What is the fact? Yeah. And maybe somebody's recollection of what may have happened.
So we would still get that in writing, even if it was, hey, I'm happy with this.
It's not impossible not to have it in writing, but it's, again, if you were ever in a situation where you've got a disagreement and you're trying to convince the third party or trying to reach a conclusion to it, can I prove to it? At this moment in time, I can't do anything about saying that this is a pen and the pen is blue. Yeah. Now, it could be that we get to it, and you say, oh, that Mont Blanc pen that you had, it wasn't a Mont Blanc pen that I was holding at that moment in time. It was a nice blue biro. Yeah. Well, you said it was a pen. You were going to give me a pen. and I'm thinking that, and you're thinking something completely different.
Yeah.
Now, if there's a photograph, or we've got
Or a video.
evidence, or a video, well, you've seen it, yes. So that is my saviour. Yeah. But my point being, without the videos, without the cameras, or without
Got
recording
nothing.
everything,
Yeah,
what have we
yeah.
got? Which is kind of, why do we need lawyers? To try and, I suppose, so far as possible, write down and record what was meant.
And that's the essence of what we tried to address here. We've tried to make sure it's understandable what joint tenants and tenants in common are, beneficial interest, that there are considerations. At which point would they be coming and speaking to someone like yourself here at Optimum?
I mean, normally we'd sort of flag it when if we've got a couple. Yeah, we do a lot of conveyancing here, so when couples are coming in, it's something we'll flag with them.
Yeah.
Just to say, in fact, we do flag it. It's like, how do you want to own the property? And
Yeah.
it's partly because the land registry, one of the forms on their documents, the TR1, which is it, panel 9, I think it is how is the beneficial interest to be held? Do you want to hold it as joint tenants? Do you hold it as tenants in common?
And I was about to ask that. So in other words, in the mortgage itself as well, it will say whether it's joint tenants or tenants in
Well, the
common.
mortgages as a rule tend to be whoever's making the application. So if you've got two names on the mortgage app, there'll probably be stuff in there about joint and several liability. In
Yeah.
Two people on the mortgage. Yeah.
Yeah.
I guess the mortgage companies maybe just wants to make sure it's gets the monthly mortgage paid every month.
Yeah.
How that money gets there, well, yes, there'll be debit account or whatever. So even if it's a joint account, I don't know if the mortgage company's too bothered.
As long as they get their money.
As long as they get the money. Yes, they would have done all of the AML and financial vetting and everything else with it. But mortgage is almost like the good example with, joint liability for the mortgage. It's joint and several. Yeah. So they'll always be wanting to.
So where does it legally say whether you're joint tenants or tenants in common?
Well, if everybody out there is now worried about how they own a property, you've got get the official copies from the land registry, public register. Everybody can do it. Slightly more expensive to members of the public than it is for through the professional portal. But the official copies have three sections. A, it sets out this is what the property is, and then you've got B, which is the proprietorship register, and then C, charges register. The important bit is B, proprietorship register, because that will state who the owner is. Okay. Now, if there are two owners, and it's held as tenants in common, beneath that there'll be what's called a Form A restriction, which basically says no disposition I'm paraphrasing here, is basically there's a restriction that prevents a sole owner, unless it's a trust corporation, being able to dispose of the property. And that is almost, I guess, jargon code word for the fact that there is a trust relating to this property. Yeah. What the terms of the trust are,
that's determined.
Well, that is determined by what is in the background. But if you saw two names on the official copies, and it's got a Form A restriction beneath that, that means that it's held as tenants in common. So if one person was coming to sell, they'd need to have a very good explanation how they had come into being in the situation to be being able to sell, because normally there's two names on the property. So why are you? What's happened to the beneficial interest? So the legal is one thing; it's what goes in the background, and there are protective measures that if you have got, and you sometimes see it where you've got, you've mentioned the example, husbands and wife, the sort of the IHT structure, that it was held as tenants in common, and say the husband's passed away and the spouse is coming to sell, and the trust, he may have left his share of the property to children.
Yeah.
But mum's looking to, or his surviving wife, the widow's looking to sell the property. She'll need to appoint, under the way that the law relating to equity works, there are ways to get around it.
Right.
Yeah. You basically have to pay the money to two trustees to overreach the interest in the trust. So they're all, I suppose, checks and balances with it. But the simple answer to the simple question that you asked was get your official copies. Yeah. Find D, find section B, Part B of them. Yeah.
Yeah.
If it's clear and there's two names and there's no restriction, then it's owned joint tenants. Yeah.
Yeah.
If it's two names and you've got the restriction, it's tenants in common.
If there's more than two names, it's tenants in common.
More than two names? No, not necessarily.
Oh, no.
No.
So that's independent from the mortgage altogether then?
Mortgage is a separate arrangement.
Yeah.
Because whether you've got a mortgage or not, you've still got the question of, yes, there may be a mortgage in the background, and yes, there's effectively the interest of the lender, but it's not the same as this is between, right, strip the lender out, it's what's left over.
So by default though, because I don't recall ever being asked the question when it came to buying our house, by default they put us in as joint tenants, presumably.
It's tenants in common these days. As a rule, if it's silent, the Lands Registry will assume, and again, that comes back to some of the detail from some of this, the assumption will be that it's held tenants in common, not as joint tenants.
Oh.
Yeah.
I bought my house 13 years ago, 13 and a half years ago. What will I be?
I don't know.
Oh,
If you
God.
get your official copies,
I will have
could,
to now.
I could tell you. And I suppose the flip of that is basically, if you think, right, I thought we owned this as tenants in common, and you haven't got the protection on there, it might be an idea to investigate further.
Yeah.
Get that sorted.
And there's a key thing you touched on is the protection in place based on what the situation it is, which option it's gone, not just which option you choose to go. I mean, hopefully we haven't confused you completely there. In essence, as you said, Iain, when you walked in going, hang on, I'm a bit worried we're going into this because it is very, very deep. We can go lots of different directions. I think we did all right.
I hope we have done. And what I will say is that I can remember back to like when I was at law school and doing all of this, I think a lot of my friends and people who I was studying with, the first things that they could opt out of doing and drop was anything relating to property and land law, and also stuff to do with trusts and equities, because it is not it's some respects it is quite easy to get your head round. In others, it starts getting complicated. And I think partly the interaction that I find that almost in the commercial arena with commercial law, it can be quite straightforward because there's no emotion. It's just about the IQ. The EQ side of things doesn't come into it. The emotional stuff isn't involved as much.
No.
Yeah. But I think before we kicked off this session, when I was mentioning my nerves and everything else around it, I think I said to you, a lot of the case law does with surrounding cohabitation and trusts, and certainly in the context of residential property, it's the interaction with couples separating, and it's driven by an emotional side of things. I can't, as a lawyer, however much I'd like to be emotionless about this, which sounds cold, it's not meant to be, because you're trying to sort of stick with, I don't know, reason and intellect.
Yeah.
Well, the whole reason the decision is made is it's not. You can't ever get away from the emotion.
No,
and sometimes it can be. Maybe it's too tough a conversation to have. Yeah, we'll just take our chances. We know there's a bridge coming. Don't know if it's going to be a rope bridge, a suspension bridge, or whatever. Yeah, we'll just cross it when we get there.
Love it.
Yeah. You might think, oh, we'll try and think of. Can you think of every eventuality? I don't know if you can. And
Not
sometimes
really.
It might just be easier for the here and now. The decision might just be we're just going to have to park that one and deal with it when we get there. And there are mechanisms to deal with it. As I said, there's the trust of land, there's stuff in the background that if all else fails, there are ways of getting this resolved. It might not necessarily be cheap, it might be a bit of a journey. You'll still reach a resolution when you get there. And
things can be changed further down the line as well.
Yeah.
And that's another reason why this episode is out there. And in the Optimum newsletter, if you should be subscribed to that, make sure you are. If you're not, you go to marketing@optps.co.uk and you'll be able to, because it's like always full of bumper stuff. Is it every month or quarter? I can't remember.
I think quarterly.
I think it is, because it's so full of stuff.
But we do have to sort of update the socials and everything else.
Absolutely, and that's on the socials right this week. Actually, is the written part about this, is that to really sort of provoke you to realise there's a conversation that either could or should be had, and there's a person that you can have the conversation with. See it on. I'm going to point at it. I can't get me directions right. So it's over there somewhere. There you go. Iain Mason at optps.co.uk. Drop Iain a line. He'll be able to speak to you. Before we wrap up, just also to let you know that next Tuesday, if you're watching this live, Tuesday the 14th of May, back here in this this very room, in actual fact, it will be the Optimum networking breakfast, totally free of charge. And yes, that does include coffee, tea, fruit juices, bacon rolls, fresh fruit, and lots of people to have a lot of conversations with. And not all clients of Optimum yet either, as well.
No, it's open door.
It is. And hopefully you can see the address there. It's here at HQ. What I will also do is that in the comments I'm going to post the link, because it's an Eventbrite link. Hopefully that'll go through to all the different platforms that you're watching this on now, and you'll be able to click that link and book yourself on to next Tuesday, so that they know how many they're catering for. I should be here as well, which I'm looking forward to, because you do them here and in your Cheltenham office as well, don't you?
Yeah.
Alternate between the two.
We do.
And next Tuesday is here at Swindon, HQ, Ermine Street.
That's right. Cheltenham tends to be more sweeter in the offerings. It tends to be pastries.
I did see that.
Yes.
I did see. Hey, you know, one man's beef's another man's poison.
Precisely.
It's all good.
Yeah.
Iain Mason, thank you so much for
Chris.
today.
Yeah.
I know you were apprehensive about coming on, but it's been a really cool discussion.
Well, I hope so. As I say, it was trying to reduce stuff that, even my best efforts to try and simplify stuff, there are moments when it is, it's not the most straightforward.
It's not a square peg, square hole, is it?
It's not. I mean, some of it is, in some respects, quite straightforward. It's, I guess, in some respects, common sense. If I'm doing something with somebody else, it doesn't matter if I was buying a house or if we were going to hike somewhere. Who's going to carry the rucksack? I mean, it's
Be sensible, be thorough, and get it documented.
Basically,
that's the big one.
Yeah.
I think that's a great way to end it. Iain Mason, thank you very much. Thank you for everybody who's either watched it live. I can see there's been a good few of you on there watching, and of course it's there to watch back or pick up where you left off. And we'll be sharing clips of this as well on social media over the coming weeks and months as well. But until next month, when we'll be back for episode 8, not sure on the subject yet. We'll get onto that very soon. But thank you for your company. We'll see you next time. Cheers.